Hello, I'm Professor Kozlowski. Welcome to my webpage at George Mason University. See a list of the courses I teach, many of which are online, web-based televideo courses. And oftentimes the materials for these courses are derived from monthly law review articles that I've written for Parks and Recreation magazine, which is the official publication of the National Recreation and Park Association. And I have a link to these articles archived on my website. As I mentioned, I've been writing this column since January of 1982. And today we'll be looking at an article from June of 2012 entitled "No Liability for Obvious Playground Fall Danger." This particular article starts out with a general overview of legal principles involving landowner liability or premises liability. And the point's made that in looking at reported case law, which really defines the state of the law, liability in general in recreational injury, but in public playground injuries in particular, liability is often the exception rather than the rule. And in terms of general landowner liability, the legal duty of care that's owed to what's called invitees, those people for whom the premises are held open for either a business or a public purpose, like public parks and recreation, public playground use. For those individuals, a landowner is generally required to inspect and repair or remove discoverable hazards within a reasonable time. If repair or removal, which is always preferable, is impossible or impractical, then landowners should provide an adequate warning of hazards. And an adequate warning generally takes a dangerous condition which is known to the landowner but wouldn't be obvious to the recreational user, and provides necessary risk information to apprise you of the general scope of the risk. That's what constitutes an adequate warning. However, if the condition is already open and obvious through the reasonable use of your senses, then there would be no duty to warn. Moreover, in determining negligence liability, it usually presupposes an unreasonably dangerous condition on the premises. And unreasonableness in this context usually presupposes that it's a condition that's known to the landowner, but once again would not be known or apparent to the injured recreational user. If a condition is open and obvious, such that through the reasonable use of your senses, the danger would be equally known by the landowner and the recreational user, then it wouldn't be considered unreasonably dangerous and provide a basis for negligence liability, which again presupposes that there's an unreasonably dangerous condition on the premises. Within this context, generally, the ordinary risk associated with falling from an otherwise safe piece of playground equipment would not be considered unreasonably dangerous. One factor, however, may be the nature of the surfacing underneath the playground equipment. Cases we'll look at today, however, this was not an issue. Now, reasonableness in the context of negligence liability is a two-way street. You as the landowner not only have to act reasonably in maintaining the premises, inspecting, repairing, or removing known or discoverable hazards within a reasonable time, principles we just went over, but that recreational user also has to look out reasonably for their own safety. And when it comes to children, The reasonable child standard are children of similar age, education, and experience. And generally there's a sliding scale that children under 7 are presumed incapable of looking out for their own safety. That presumption still applies for children 7 to 14, but it can be rebutted. You can show under the circumstances a particular child should have known better. The presumption reverses, however, 14 to 18. The presumption is that the child should be able to look out reasonably for their own safety, like an adult, 18 or over. But once again, you could rebut that in a particular situation, showing that this particular child under these circumstances would not be expected to be able to look out reasonably for his own safety. However, within the context of public playgrounds, as we'll see, absent any unusual hidden hazard, again, an otherwise reasonably safe piece of playground equipment with adequate surfacing underneath, the risk of injury associated with falls from heights, is generally considered an open and obvious risk to any child old enough to be at large. So the risk of heights, the risk of fires hot, you can be burned, or drowning in a body of water not designated for swimming, those are considered open and obvious risks to any child old enough to be at large, and generally would not provide a basis for landowner liability. So this open and obvious risk associated with falls is one factor we'll be looking at in these playground injury case examples. As the popular media tends to erroneously portray the law in terms of equating serious injury or death with liability, particularly where it involves a child. And they say, oh, well, Johnny fell off the playground equipment and broke his arm, and they'll sue the landowner, public agency, and there'll be some sort of liability. Ignoring the fact that, particularly in the public sector, there's oftentimes limited immunity available, a whole range of statutes depending on the particular jurisdiction. But there also may be limited landowner immunity, as we'll see in one case, under a state recreational use statute, which provides where the landowner opens his land up for public recreational use free of charge, the invitee legal duty of care does not apply. There's no duty to inspect, repair, or remove known or discoverable hazards within the reasonable time. There's no duty to guard, warn, or make the premises reasonably safe as you would in an invitee situation. Their only duty is to avoid not ordinary negligence, but gross negligence, willful wanton misconduct, conduct wherein there's a trap-like situation, and beyond mere carelessness, which might be evidence of ordinary negligence, for willful wanton gross negligence, there has to be an utter disregard for the physical well-being of others. So we'll look at a couple of cases involving an open and obvious risk of falls, and generally a participant in any activity, sports, athletic, or otherwise, play activities, assumes the inherent risks associated with that activity. So one plays football or a contact sport, and the inherent risk is that you're going to be banged around. And so to the extent that you proceed to participate in light of open and obvious risk, the general scope of which should be evident through the reasonable use of your senses, we'll see that you may be deemed to have assumed the risk. The assumption of risk defense may kick in. And although this made more difficult when you're involved with children, particularly those 7 and under, but child's over the age of 7, despite even under children of similar age, education, experience, the child standard will find a child may indeed have assumed the risk of injury associated with falling from heights. And we'll also see a case involving limited immunity under a state recreational use statute. So the first case here, the title is Slanted Roof Case Study, involves a case of Kane versus Landscape Structures. Here, plaintiff Stephen Kane is age 9, and he's seriously injured when he fell attempting to climb playground equipment at a Gwinnett County Park, Georgia mountain park. And this park contained playground equipment for children of all ages, but it also included specifically an infant maze, which was designed for use by toddlers. And there were other structures for older children. Despite this, we'll see Kane and his friends were effectively misusing, if you will, the playground equipment that was meant for toddlers, and perhaps this misuse, inappropriate use of playground equipment by older kids may have been partially the fault of the older children, the injury, and a failure, even at their age, to look out reasonably for their own safety. So Kane had visited this playground many times, suggesting his knowledge of the site and any risk knowledge, if you will, would perhaps been similar or equal to that of the landowner. Now, the infant maze where the injury occurred consists of a series of 31-inch high vertical panels and cutouts to help toddlers hold on to handholds, maintain their balance. But above the infant maze on 4 posts was a 7-foot-high slanted roof, providing an enclosure coverage, but in no way meant to be or understood to be, even by a child of age 9, that this was somehow part of the climbing apparatus. So on the day of the injury, Kane noticed several older children were jumping from the roof structure within the infant maze, but they sat atop the roof structure and encouraged Kane to join them. And to do so, to get up on the roof, Kane, as you see, had to engage in some rather gymnastic, contortionist acrobatics, reaching up, getting his leg up in order to have the other children be able to pull him up. In so doing, his foot slipped and he fell and effectively impaled himself on a panel below and was seriously injured. Now, in terms of an assumption of risk, you look at the subjective appreciation of the individual in their own mind. Were they aware of the risk they were taking? And in terms of, under the circumstances, was Kane here, even at age 9, acting reasonably under the circumstances? Here, Kane admitted he knew the infant maze was intended for little kids, and in fact, it was not designed for children of his age, suggesting that he knew that his use of the infant maze was indeed inappropriate, that there was nothing unreasonably dangerous about the particular piece of play equipment. What made it unreasonably dangerous was Kane's use of it, the activity, trying to climb up on the slanted roof. And he further acknowledged that climbing on the roof structure was not an intended use, that it was not part of some suggesting climbing structure or alike. So while conceding the roof structure was not something which he ought to climb, Kane claimed somehow he wasn't really thinking about it because he was a kid. But even as a kid at age 9, children of similar age, education, and experience, to what extent, through the reasonable use of his senses, would the risk, general scope of the risk, be open and obvious to him? While he may not have expected to fall and get impaled and seriously injured, was he generally aware, subjectively appreciated that in trying to climb onto a slanted roof, that he indeed could slip and fall? He doesn't have to know and appreciate exactly how the accident's going to go down, as long as in his own mind he appreciated that he could get hurt in the way he did generally in terms of a fall. Now, Kane noted not only, well, I'm a kid, but the infant maze didn't bear any warnings about the danger of climbing on it. Remember we said earlier in terms of when is a warning required? When the general scope of the risk wouldn't be otherwise obvious through the reasonable use of your senses. If it is open and obvious, hey, it's not a good idea to climb on a slanted roof because you may fall off and get hurt, then no warnings are required. Keep in mind as well, this infant maze is designed for use by toddlers, so you might question, you might say, well, they'd often, for the most part, be accompanied by adults, but children using it, when it's designed for toddlers, wouldn't be able to read any warning anyway. So to what extent would any warning tell Kane something he shouldn't have already known and appreciated? So here Kane sued the playground equipment manufacturer Landscape Structures, alleging negligent design of the infant maze. And there was nothing wrong with the design, as it was designed for toddlers. As I said before, the problem of any was the inappropriate use by Kane, not negligence in any part of the equipment manufacturer or the park landowner. And we've already looked at his allegation, failure to warn of the dangers associated with climbing it. Warnings tell you things, apprise you of hazards you wouldn't already be expected to know. The open and obvious risk of trying to mount this slanted roof and the risk of falling off it should be open and obvious even to a child of 9 years old. And given Kane's testimony, it seemed that he admitted he wasn't supposed to be doing it in this fashion, and it might not be a good idea. So in response, the defense, Landscape Structures, argued Kane had assumed the risk of falling from the infant maze when he attempted to climb atop the structure. That in this activity, if you will, that indeed was an inherent, open and obvious risk to anyone trying to pull off this stunt, even Kane at the age of 9. So the trial court agreed and granted summary judgment in favor of Landscape Structures, effectively dismissing the case. Kane appealed. So up on appeal, we're looking more at the defense of assumption of risk. And the appeals court noted to establish assumption of risk, Landscape Structures would have to show that Kane had actual knowledge, subjective appreciation of the danger. He didn't have to know exactly how he was going to get hurt, but was the general scope of the risk. Hey, if I attempt to climb on this slanted roof, the difficulty involved getting there and needing my friends to help pull me up, what's the risk? The risk is that I may fall and get hurt. And that he understood and appreciated that danger, and said generally the risk of falling from heights is charged to a child of any age, old enough to be at large, and that he voluntarily exposed himself to the danger. Clearly, it was consensual on his part. He saw the kids up there, other kids, and he wanted to get up there with them. So in terms of assumption of risk, the appeals court noted further this idea Not that most people would know, but you have to show in his own mind he subjectively appreciated, was actually aware of this particular risk of harm associated with the activity or condition. And the risk of harm here is you're going to slip and fall off the structure. You don't have to know and appreciate. You might say, well, yeah, I thought I could probably get hurt, but I didn't realize I was going to get hurt that bad. That's irrelevant. It's not the severity of the injury, but is the risk of injury open and obvious through the reasonable use of your senses. So in this particular instance, the appeals court found, looking at the particular risk of harm, was the danger of falling from an elevated place onto some object below. So if you're climbing aboard the infant maze and it's clear that the 31-inch panels are surrounding it and you're climbing onto a slanted roof, the general scope of the risk would be apparent. If you fall, you may indeed encounter those panels on the way down. Kane, however, stated while acknowledging he understood the general risk of falling, he denied having any, quote, particularized subjective awareness of the risk involved in climbing the structure. But he admitted he was subjectively aware that he could fall and get hurt. And for assumption of risk, you have to appreciate the general scope of the risk, which he did, falling, and you don't have to appreciate. Most times people are going to say, well, yeah, I didn't think I would get hurt that bad. It's not the particular nature or severity of the injury, but you subjectively appreciate the general scope of the risk, which the evidence here seems to suggest that Kane indeed had the requisite knowledge. Kane, however, contended he was not fully aware, appreciated the risk of falling to the, quote, seemingly innocuous appearance of the structure, and he had not observed any children fall from the structure. But again, despite its seemingly innocuous appearance, it was meant for toddlers. The risk of falling when you climb on top of a slanted roof, where you acknowledge that that was not designed for climbing on, that it was inappropriate, that you're taking a chance in trying such a stunt. And as a participant, you would assume the risk of injury in trying to perform such a stunt. Kane, however, claimed that the evidence was insufficient, that he knew that standing atop a narrow vertical panel on 1 foot while trying to climb onto the roof of a playground structure several feet above necessarily indicated he appreciated, assumed the risk of falling onto a visible, and that's goes to the open and obviousness of visible panels beneath the roof. So engaging in such an activity, just like you as a participant assume the inherent open and obvious risk in football of contact, wouldn't indeed engaging in this conduct of standing atop a narrow vertical panel, 1 foot climbing onto a roof, that an inherent risk, therefore assumed risk of engaging in such an activity, that you may fall and encounter visible panels on the way down. So here, the appeals court rejected Kane's argument. In the appeals court, undisputed evidence, relevant law, points have been talking about in terms of assumption of risk, and moreover, the dictates of common sense supported the trial court's decision to grant summary judgment for landscape structures. Once again, reasonableness is a two-way street, that even the 9-year-old child had to look out reasonably for his own safety, like children of similar age, education, experience. As the court noted, law doesn't expect children always to appreciate the dangers like adults. We've looked at that child standard. But Georgia courts and courts in general have recognized children as old as Stephen at 9 are quite capable of appreciating certain obvious dangers. And one of those dangers is the danger of falling from obvious heights. They noted that including the danger associated with climbing or jumping from an elevated place. And they noted that no danger is more commonly realized, obvious danger, or appreciated, and therefore forms a basis for assumption of risk, even by children, of falling from heights. And they noted here, and that's why they mentioned that cutoff time, normally a child nearly 7 years of age, and indeed, as I stated, any child old enough to be at large, that's the general approach, knows that if you slip or fall from heights, fall to the ground, you get hurt. And even though children realize it and they choose to ignore it, that doesn't make it any less obvious. It's due to their, as the court stated, immature recklessness, their failure to look out reasonably for their own safety that's the cause of the injury. Engaging in such venturous behavior, such stunts, and certainly shouldn't be a basis for either landowner liability or here for the playground equipment company. So applying this reasoning to the facts of the case, appeals court found Cain was a child of sufficient intelligence to appreciate the obvious danger of falling. That there was nothing about the appearance of the infant maze, it was what you see is what you get, that he concluded that he wouldn't fall from the structure. The difficulty he encountered in trying to mount it in the first place just prior to his fall and needing the help of the other kids and the like gave him a heads up that maybe this isn't a good idea, that if he does so he may get hurt. And he admitted himself he knew the structure trying to get on the roof was not intended for climbing, that it was a cover for this piece of equipment that was designed for toddlers, not children of his age, so it was an inappropriate use on his part. Furthermore, the panel that he fell onto didn't expect to or anticipate the severity of the injury, but that made it no less open and obvious and visible. And its hardness would have been apparent to anybody encountering the structure. So the fact that he didn't think he would fall or get hurt as bad as he did doesn't undercut the fact that it was an open and obvious risk of falling. He doesn't have to foresee how bad he gets hurt or the severity of the injury, as long as he subjectively appreciated while he engaged in this stunt the general scope of the risk, which was that he may fall off the roof, which is exactly what happened to him. So as a result, appeals court found, like most children of 9 years old, he should have appreciated the obvious risk of falling associated with climbing to high places, which is generally ascribed that it's an open and obvious risk, therefore there's no duty on the part of the landowner for children of any age or old enough to be at large. And the court went on to find that applying the principles of assumption of risk, an assumption of risk is a voluntary encounter with a known danger, a danger that's known and subjectively appreciated. And given its testimony in the circumstances of this case, appeals court found that indeed Cain had chose to voluntarily assume the risk. And since he'd assumed the risk as a matter of law, assumed the risk of injury associated with climbing the infant maze, appeals court affirmed the summary judgment of the lower court in favor of landscape structures, effectively dismissing the case. So let's look at another example, and this is the case of the Red Wagon Slide, which is a piece of popular play sculpture, if you will, in a city park in Spokane, Washington. So it's Swinehart versus City of Spokane. It's a Washington appellate case that was issued July 15, 2008. And in hard copy, it can be found at volume 187, Pacific Reporter 3rd Series at page 345. Nowadays, however, in most cases, you would simply use that site in an electronic search to pull up electronic copy on popular databases like Westlaw or LexisNexis. Here, plaintiff William Swinehart is age 59 at the time, and he sustained serious back injuries after sliding down the Red Wagon slide at Riverfront Park, Spokane, Washington. And this is a pretty imposing piece of play sculpture, if you will. It's meant to be used as play equipment. Giant replica of a radio flyer wagon. It's built by a local artist as an interactive sculpture playground piece made primarily of metal and concrete wheels. And despite its artistic value, oftentimes an issue comes up that it still has to be reasonably safe under the circumstances. So you don't sacrifice safety, if you will, so it looks like, well, if we made it safe, it wouldn't look like a dragon or whatever. But here the question didn't come up whether the design of the Red Wagon, although artistically honest, did it sacrifice safety in its design. Once again, not an issue here, but sometimes with these play sculpture pieces, it is an issue. I've been involved in several instances which that was the case. All right, so since its installation in 1990, it's been a popular park attraction for both children and adults. Everybody wants to go down the slide in the Red Wagon, which is effectively the handle to the Red Wagon. So you can see the dimensions. It's a very large piece of equipment with an attached slide to look at, like the handle, and it's 8 feet 8 inches off the ground, and there's an angle of 30 degrees. Then the question would be, well, to what extent would that stack up with specs for a reasonable safe slide? Not an issue here, because once again, as we saw in the previous case, we're looking at to what extent might it be an open and obvious risk. What you see is what you get if you want to go down the Red Wagon slide. So you climb the stairway at the back of the wagon, get inside the wagon, and you can proceed either go back down the stairway or go down the handle slide. So Swinehart observed Red Wagon. Question is, through the reasonable use of his senses, could he subjectively appreciate in his own mind the general scope of the risk he may encounter if he chooses to go down the slide? He went over to take a closer look, get some pictures for the granddaughter, and to get a better picture, he climbed the ladder of the wagon while Mrs. Swinehart took pictures of him. So to get down, he had the option of going back down the stairs, but he decided to go down the slide. So in so doing, was he voluntarily encountered and known a risk, assuming the risk? When he went down the slide, he landed directly on his buttocks on a wood chip surfacing at the bottom of the slide, suggesting that perhaps the surfing was reasonable. And as a result, he sustained lower spine injuries and a compression fracture to his vertebrae, effectively broke his back. So he brings a lawsuit and claims the playground fill was insufficient and improperly maintained, not only under the city's standards, but playground industry standards regarding the thickness you need of a surfacing equipment under playground equipment. But circumstances in the use of a slide, people coming down, landing, and it's expected perhaps open and obvious that the surfacing would be scuffed away by repeated use. So plaintiff's expert testified national playground safety standards required slides of a height of 8 feet 8 inches to have a minimum of 12 inches of organic fill in a loose and uncompressed state. That's plaintiff's expert saying, well, that's why this particular piece of playground equipment was unreasonably dangerous under the circumstances and perhaps could provide a basis for ordinary negligence liability. But as we'll see, if the recreational use statute is at work here, then you have to show not ordinary negligence, but was this lack of fill material grossly negligent? So Parks Department official admitted that in terms of the risk of playground injury due to falls, the reasonable care usually requires some sort of reasonable surfacing material. And Parks Department official admitted the proper amount of wood chips is important in the prevention of fall-related injuries, and the lack of material or overly compressed surface could increase the likelihood of injury. And that they had their own standard similar to the industry standards, which again is evidence of what might be reasonable unless it's actually been legislated. And oftentimes these, quote, standards have not been passed into law, so they're simply evidence of what might be considered reasonable under the circumstances. Here, the city's own standard was 12 inches of wood chip fill, but they acknowledge that the playground fill is known to become displaced or compacted at slide exits despite daily inspections. So would that make it unreasonably dangerous, or would you have to effectively have somebody there each time an individual would go down the slide to effectively rake the landing area to make sure it's back to 12 inches? If that were the case, you probably couldn't have a slide in any playground. Swinehart presented photographs showing that the wood chips were widely dispersed and there was a pit or depression serving as a landing area rather than level surface. Is this an inherent risk, if you will, in the usage of any playground slide? If that were the case, then every slide out there, as I said, would probably be unreasonably dangerous and you'd have to get rid of it. Here, plaintiff's expert inspected and said that the fill material was 2.5 inches compressed wood chips. Trial court granted summary judgment in favor of the city, but based upon the state recreational use statute. So even if this is perhaps ordinary negligence, if the state recreational use statute applies, then you have to show gross negligence, not mere carelessness, but an utter disregard for the physical well-being of others, such that the condition is not unreasonably dangerous, but is more like a trap. And here, while not the best, and maybe even you concede it might be a case of ordinary negligence, 2.5 inches under the slide, under these circumstances with daily inspection, is evidence of some care, certainly not utter disregard, the type of evidence you would need to overcome immunity under the state recreational use statute. So let's take a look at the court's analysis of the recreational use statute. And here, and most of these statutes fairly similar and based for the most part on a model state statute from 1965. And the Washington recreational use statute issue here provided that any public or private landowners, lawful possession and control any land, who allow members of the public for purposes of outdoor recreation without charging them, are not liable for unintentional injuries, carelessness, but it suggests you may be liable for intentional injuries or outrageous misconduct, typical of willful wanton misconduct. So this is fairly standard because generally recreational use statutes provide that if a landowner opens their land for public rec use free of charge, they owe no legal duty to guard, warn, or make the premises reasonably safe. They simply have to avoid willful, wanton, or gross negligence. Now, some statutes seem specific to private landowners, and either by court interpretation or as here, it's specifically expressed language of the statute, immunity is not limited to private landowners, as it is in some other jurisdictions. But the general rule, either by court decision or express statutory language, these state recreational use statutes have been generally applied to public entities. Here, City of Spokane. So the court took note of that public lands are expressly included and have been applied to municipal parks in Washington. Some states have limited the scope of state recreational use statute immunity to the quote great outdoors, so more woodsy activities. So it might apply to a state park, a resource-based area, but not a municipal park. But that's not an issue here in Washington. Their statute's fairly broad. However, these statutes tend to have jurisdictional wrinkles to them, and the Washington statute has one such wrinkle and says that it does not limit a landowner's liability when sustained by reason of a known, dangerous, artificial, meaning generally man-made, latent condition, which suggests something that's hidden as opposed to open and obvious, where you don't warn about it, for which no warning has been posted. So here the fill under the slide is certainly man-made. It's not natural, but was this scuffing away of the surfacing a hidden, latent condition that would trigger the exception to state recreational use statute immunity, or was it the general scope of the risk open and obvious through the use of Swinehart's senses? Here, once again, Swinehart argued the limited immunity did not apply because of the insufficient and improperly maintained fill at the slide exit constituted known dangerous latent condition. Was it indeed latent and hidden from Swinehart? So the court said latent, just the dictionary definition is, was it not readily apparent to the recreational user? And the court said conversely, a condition would not be latent if it's obvious. So recreational users, anybody using the slide, would be aware that the surfacing had been dispersed and scuffed away at the base of the slide by repeated use people landing there. So the court found that the displacement of the condition of wood chips was not latent, that in fact it was patent and obvious. Found visitors at the playground could visually reference, just by looking at it, the fill around the slide to determine whether fill existed, so that depression at the bottom of slides, typically at the bottom of most slides, would be open and obvious, apparent through the reasonable use of your senses before you go down. And that recreational users, the court found, including Swinehart, could reasonably be expected, looking out reasonable for their own safety, to differentiate between a compact and deteriorating surface and loose material, because the feel and appearance would look different. You would see that depression at the bottom of the slide. So while revealing the displacement of the wood chips, the large pit or depression, appeals court here, remember he was there, they were taking pictures, Swinehart's own photographic evidence underscored that the condition should have been obvious, that it was not latent. Therefore, to overcome immunity under the state recreational use statute, this displaced wood chips, Swinehart would have to show that it was not mere carelessness, ordinary negligence, that it was gross negligence, willful wanton misconduct, either conduct equal to an intent to injure or reckless, outrageous misconduct demonstrating an utter disregard for the physical well-being of others. So even though 2.5 inches of fill was below standard, it wouldn't demonstrate a total lack of care necessary to overcome the statutory immunity. Once you find that under this Washington state statute, it was not a latent condition. So the photographic evidence, Swinehart's own pictures revealed not only a poor condition of wood chips, poorly maintained surface at the slide exit, but most importantly, a condition that was visible and obvious at the time of the accident. And you choose to get down the slide, not turn around and take the stairs, not only under ordinary negligence principles we saw in the previous case that you may be deemed to have assumed a risk, but such an open and obvious condition would not be sufficient to overcome the immunity under the state recreational use statute. So the court noted if it was indeed latent, not visible and obvious, that such a condition could not have been captured by a photograph. So it shows that indeed what Swinehart should have seen. So as a result, having found the condition to fill was obvious, readily apparent to slide users, not latent, in order to trigger the exception to the state recreational use statute, the appeals court affirmed the summary judgment to the city, throwing Swinehart's case out based on available immunity under the state recreational use statute. Let's look at another slide case here. Jet slide for toddlers. In this case of Kozlowski versus City of Long Beach in New York. It's a case from March 7th of 2011. Here, Neil Kozlowski's age 3.5, and he's injured when he fell from a playground slide. And he was at the top of the slide before sliding down, and neither Neil's father and grandfather, both present at the playground, they were both present, but neither of them saw Neil fall. So years later, now he's 8, testifying about what happened when he was 3. He said another kid pushed him off the slide. He tripped at the slide and fell through an opening to the slide. And Neil's mother testified he told her at the time he had tripped before falling. She said her son had used the slide at issue 400 times on other occasions before the accident without a problem. So 2 issues here. If it's an intentional act of another kid pushing him off the slide, then the slide didn't cause the injury. If not, then the question is, if you trip and fall, is it a fall from an obvious height that we've seen is considered open and obvious to any kid old enough to be at large, here 3.5, such that there's no legal duty on the part of the landowner. Plaintiff here alleged the slide was unsafe for children under 5 because the slide openings were too large for younger children, and that the city should have provided a warning, presumably to parents because the kids aren't going to be able to read it, that the slide should not be used by children under 5. And further, they contended the city had failed to separate the slide at issue from other playground equipment based on age restrictions. So generally, you try to segregate the older kids' equipment from the younger kids' equipment. But is the failure to do so necessarily negligent? And again, particularly to the grandfather and father, was it as safe or as dangerous as it appeared to be when they chose to allow the 3.5-year-old to access the slide? Here, a manager for the playground manufacturer said that this particular slide was intended for children 2 to 12 years old. And further, this slide was designed, tested in accordance with the Consumer Product Safety Commission Public Playground Safety Guidelines from the U.S. Consumer Product Safety Commission. Now, this is generally referenced in terms of public playground safety, but they are guidelines. And unless they're legislated, they don't establish the applicable legal standard. They're only evidence of what the legal standard may be in a particular case to the extent it reflects customs, practices, usages in the field, here public playgrounds. The Play World manufacturer compliance manager testified this particular slide had passed all of the tests, the probes of openings and the like, under the existing CPSC guidelines. And based on these tests, it would ensure, given the fact that playground equipment was 2 to 12 years old, that a 2-year-old, even in the minimum percentile, in other words, a real tiny kid, wouldn't fall through the openings of the jet slide. So based on this evidence, the city maintained that the slide was appropriate for children ages 2 to 12. So in some cases, they segregate equipment 5 and under or 5 to 12 in terms of placement of equipment. But here they're saying that that doesn't necessarily mean that this particular piece of equipment was inappropriate for anybody under 5. So the city contended plaintiff couldn't establish negligence for a failure to warn the slide was not appropriate for children under 5, because indeed their contention was that it was appropriate, pursuant to the testimony of playground manufacturer, for children 2 to 12, based upon the CPSC recommendations. Furthermore, city's assistant superintendent rec testified the slide was inspected daily and had no defects, found any complaints about the slide prior to Neil's accident. So was this a fall from an otherwise reasonable piece of playground equipment? Might the fall, not an issue here, be attributable to, lack of supervision on the part of the father and grandfather for this 3.5-year-old? So the court noted municipalities under duty maintain its playground in reasonably safe condition, not make it injury proof. Here, there was evidence established the city had inspected the playground and issued daily, and there was no indication that it was defective, that they hadn't received any complaints prior to the accident. So in terms of inspecting, repairing, or moving in a reasonable time, the inspection, there was no indication that there was anything unreasonably dangerous and defective about this particular piece of playground equipment. Furthermore, given the manufacturer's testimony, there's no evidence of record the city of Long Beach should have known the slide in question was not appropriate for the age group using the playground, or that the failure to separate the slide at issue from other playground equipment, because again, he was there with his dad and grandfather, in any way caused the injury. The cause of the injury apparently was a trip and fall or a fall from an open and obvious height, which there's no duty of care, no landowner liability, that falls from heights, here from this particular piece of playground equipment, would be considered an open and obvious risk for any kid old enough to be at large. So applying the sort of reasoning we've seen in the other cases as well, once again, this court concludes that the summary judgment in favor of both the manufactured play world and the city should be affirmed and dismiss the case. So here's a couple examples, and fairly typically in most of these, despite the doom and gloom in the popular media, unless there's some sort of hidden dangerous condition involved, and surfacing can be an issue, not so much so the case here in Swinehart. It was the recreational use statute that addressed that contention. But generally where it's just a generic fall for an otherwise reasonably maintained piece of playground equipment, the vast majority of cases, once again, generally in terms of recreational injury liability, but playground injuries in particular, liability should be exception to the rule based on reported court decisions. And here we've seen several examples of the kind of court decisions that you would expect, that the vast majority of them don't involve equating, well, if somebody gets hurt, therefore somebody must be liable. So that's all the time we have for today. We'll see you next time when we'll look at another law review article and get a better idea of general legal principles on a variety of topics, including liability involving parks and recreation. I'm Professor Kozlowski. We'll see you next time.